Good morning, everyone. Virgo here. It is August 1st, 2019, and welcome to Snoop4Truth. So a lot of you might remember that 2 weeks ago, I did a Snoop4Truth with regards to the right to travel argument. The video is called the No Driver's License Fantasy. And you can find that if you go to the homepage of the Virgo Triad channel, look under playlists, and you will find a playlist that is entitled Snoop4Truth. It has a bunch of videos in there that we will continue to add to on a weekly basis, where Snoop4Truth does a bunch of research for us, finding case law and different areas that prove what the reality is with regards to this right to travel argument, which of course it is false. You do not have the right to operate a motor vehicle on the roads in any state in this nation without having a driver's license. Driving is indeed a privilege, not a right. Today we're going to be finishing up the case law with regards to this argument, and we're going to be looking at some interesting facts that are up on the internet confusing people in addition. There may be a part 3 to this video because it is such a large subject with regards to these individuals. So just fair warning, we may have a total of 3 parts now instead of just 2. I'd like to thank Snoop4Truth for all the wonderful research and assisting to try to help those to not fall into the pitfalls of these hoaxes and scams that the interesting fringe groups attempt to try to put up and push. Let's go ahead and get started. So I'd like to put your attention over here to the wearechange.org website. This specifically gives you a bunch of false information that's cherry-picked, and it also states the U.S. Supreme Court says no license is necessary to drive an automobile on public roads. Shows you a nice picture of the U.S. Supreme Court from several years ago, and then goes in to try to explain using, of all things, cherry-picked case law, in which we're about to go over so that we can discuss what it is that they're claiming. Now, we're going to call this substitute case law. So amateur legal theorists cite a number of decisions in support of their false claims that they have a unregulatable right to travel. Not right to travel, right to drive or operate a motor vehicle without a driver's license. Let me state that again. False claims that they have a unregulatable right to drive or operate a motor vehicle without a driver's license. All right, let's go ahead and take a look at some of the actual information via case law that they go over and talk about what it is that they're cherry picking and how they're spinning this to make it appear as though this is something that's sort of kinda close to. Okay, so the case law that we're going to be looking at first is Escobedo versus State of California Department of Motor Vehicles. And I'm going to be taking you down to paragraph 10 for those of you that want to follow along, or for those of you that want to take a look when you're watching this video. The links will be in the description, and you can go down to paragraph 10 about 30% or so of the way through. Where the argument is on We Are Change that it sort of kind of seems like that we have the right, because it's claiming that we have the right to use the roadways, but yet they don't consider the fact that it's not giving you the alleged right to drive/operate a motor vehicle, without a driver's license. So let's read what the actual case says. It says the streets of a city belong to the people of the state, and the use thereof is an inalienable right of every citizen, subject to legislative control or such reasonable regulations as to the traffic therein, or the manner of using them as the legislature may deem wise or proper to adopt and impose. Let me read that again, okay? So the streets of a city belong to the people of the state, and the use thereof is an inalienable right of every citizen. But you can't stop there. subject to legislative control or such reasonable regulations as to the traffic therein of the manner of using them as the legislature may deem wise or proper to adopt and impose. And all states require you to have a driver's license because that is the manner that legislature deems wise and has adopted and imposed. But they don't go in to tell you that now, do they? So we're going to look at another case here that is quoted and cited on We Are Change. Okay, so looking at Barbarian versus Lassier. This is a Supreme Court of Rhode Island case from 1958. We're going to take a look at the... let's see. Okay, so once again, we are talking about the same exact subject with regards to We Are Change's website. And this one kind of really blows it out of the water here because let's see what the actual court document says. The case actually says the Court of Appeal of Louisiana in the case of Hughes versus Department of Public Safety recognized that although an operator's license was not a property right, it was a right which was protected by the Due Process Clause. In that case, the court stated at page 130, a license to operate a vehicle upon the highways of the state is a privilege and not a property right. So here now we're actually talking about the right to not have or have a driver's license. Again, cherry picking. So let's move on to the next one. So the next case that we're going to is Holland versus Shackelford. This is one that is also on the We Are Change website. The interesting thing about this particular case is this case is actually about the property rights of neighboring property owners. Has nothing to do with driver's licenses at all. This will be linked in the description, however, if you'd like to take a look at it for yourself. Again, cherry picking. Okay, so over here, he's talking about Kent versus Dulles. You know, it's really interesting because some of the cases that they choose to talk about supposed right to travel and operate an automobile have absolutely nothing whatsoever to do with driver's licenses. So in the case of Kent versus Dulles, which will be located, of course, like all others, in the description of this video, we are talking about a case that is about an international passport, not about a driver's license at all. If you look at paragraph 14, about 30% of the way through, it will let you know exactly what this case is talking about. I am not going to go through and read this one. Many of you have already spoken to me about this particular case. It's one that the Moors love to push. You can tell that by reading through it very rapidly, this case has absolutely nothing to do with having a driver's license. This one actually really kind of cracked me up when I read it. I hadn't actually heard of this one before Snoop4Truth, but in regards to Barbara White on habeas corpus, this case is about a prostitute's right to live in a designated no prostitution zone while on probation, not about a driver's license. But yet, you know, the statement that this somehow has something to do with right to travel or use an automobile or a motor vehicle or have to have a driver's license is somehow something that they feel is you know, they're gonna be able to use this right to live in a designated no prostitute zone case for. So at the 23rd paragraph, at about 60% of the way through it, you can read that text and see what I'm referring to here. Again, the link will be in the description. Okay, so we're going to talk a little bit about right versus privilege. So these amateur legal theorists cite exactly 6 cases which inartfully characterize driving/operating a motor vehicle as a quote-unquote right. Amateur legal theorists mistakenly believe that if an act is inartfully characterized as a quote-unquote right rather than a quote-unquote privilege, then that quote-unquote right cannot be regulated, granted, denied, or revoked by the state or federal government. But this is not so. An amateur legal theorist would know this if they bothered to read the entire decisions rather than merely a part of them. Note that none of the decisions that we're going to be talking about today say that driving or operating a motor vehicle without a driver's license is a quote-unquote right. But amateur legal theorists nevertheless use the following decisions that I'm going to be going over with you as, quote, substitutes for such a decision anyway. We're going to start with Thompson versus Smith. In Thompson versus Smith, once again, you will find the link in the description of your video if you want to go ahead and look it up. This case recognized the right, quote-unquote, to travel, quote-unquote, to transport, quote-unquote, to use the ordinary and usual conveyances of the day, and, quote-unquote, to drive a horse-drawn carriage or wagon. But most importantly, this case also recognizes the, quote, right to, quote, operate an automobile, not the alleged right to, quote, drive, operate a motor vehicle without a driver's license. Beginning in the 45th paragraph at about 60% way through the text, but immediately thereafter, the very same case reads, the exercise of such a common right, the government may under its police power regulate in the interest of the public safety and welfare, meaning the government may require driver's licenses. The regulation of the right to travel right to drive a private automobile on the streets may be accomplished in part by the government granting or refusing and revoking permits, meaning driver's licenses, to drive an automobile on its streets. Did everybody get that one? So this alleged right is what most courts characterize as a privilege, because it can be regulated, granted, denied, and revoked. Thus, contrary to the claims of Eddie Craig and the other amateur legal theorists, this case does not authorize driving/operating a motor vehicle without a driver's license, and this case does not prevent the states from requiring driver's licenses. Indeed, the reverse is true. Not that it makes any difference, but this case has no application outside of Virginia anyway. Now we're going to take a look at Adams versus City of Pocatello. Once again, this is going to be located in the description so you can follow along, or you can read the entirety of the case if you choose to. In this case, the court held the, quote, the right to operate a motor vehicle upon the public streets and highways is not a mere privilege, it is a right, but the very next paragraph reads, quote, the right of a citizen to operate a motor vehicle upon the public highways and streets is subject to reasonable regulation, like the requirement of a driver's license by the state in the exercise of its police power. Citing Thomas versus Smith directly before this one as authority, which characterizes operating an automobile as a regulatable, grantable, deniable, and revocable right. So this alleged right is what most courts call a privilege, because it can be regulated, granted, denied, and revoked. Thus, contrary to the claims of Eddie Craig and other amateur legal theorists, this case does not authorize driving/operating a motor vehicle without a driver's license, and this case does not prevent the states from requiring driver's licenses. Indeed, the reverse is true. Not that it makes any difference, but this case has no application outside of the state of Idaho Anyway, next we're going to be taking a look at Tech Lines, I believe that's how you pronounce it, versus Danforth. Link located in the description of this video, of course, if you want to follow along. However, let me tell you, this case does not have anything to do with a driver's license. It's not a driver's license case. This case involved a challenge to a Mississippi statute which prohibited drivers from stopping vehicles along roadsides unless the road shoulder and the remaining roadway clearance was of a specific minimum size. This statute effectively banned all stops along the roadsides except for emergencies and made it difficult for bus companies to pick up and drop off their customers. The court held that the right to travel, including the right to stop along roadsides for usual and customary purposes, and quoted Thompson versus Smith, the case that I went over 2 cases ago with you guys, as authority which characterized operating an automobile as a regulatable, regulatable, grantable, deniable, and revocable right. But 2 paragraphs later, this very same case reads, the exercise thereof of this so-called right to operate an automobile may be reasonably regulated by legislative act in pursuant to or of the police power of the state, including the requirement of a driver's license. So this alleged right is what most courts characterize as a privilege because it can be regulated, granted, denied, and revoked. Thus, contrary to the claims, of Eddie Craig and other amateur legal theorists, this case does not authorize driving or operating a motor vehicle without a driver's license, and this case does not prevent the states from requiring driver's licenses. Indeed, the reverse is what's true. Not that it makes any difference, but this case has no application outside of the state of Mississippi. Okay, some new information that especially those that follow people like Van Balen and Scam Stingers are going to appreciate having. You hear these people discussing on a regular basis criminal stops versus traffic stops. A lot of the amateur legal theorists mistakenly believe that an officer must actually witness a crime before he or she may lawfully make a routine traffic stop, but this is not so. Unknown to most amateur legal theorists, there are 2 different types of stops involving officers and motor vehicles. There are criminal stops and there are traffic stops. Criminal stops involve crimes like selling illegal drugs or possession of stolen property, which are not mere traffic violations. On the other hand, traffic stops involve traffic violations like speeding or having expired tags, which are not crimes. So while both types of stops involve motor vehicles and officers, criminal stops and traffic stops are 2 entirely different things. The law on criminal stops does not apply to routine traffic stops. Instead, criminal law applies to criminal stops, and traffic law applies to routine traffic stops. So while a crime is necessary in a criminal stop, no crime is necessary for a routine traffic stop. Only a traffic violation is necessary. But amateur legal theorists get these 2 entirely different legal subjects very confused and therefore mistakenly conclude that an officer must actually witness a crime like selling illegal drugs to lawfully stop a driver for a traffic violation like having an expired tag. But this is not so. We're going to take a look at the People versus Glover now. Actually, really quickly, let me just say this. I've tried 3 times to pull this case called People versus Horton up, but unfortunately the case does not want to come up for me. I'm not sure what has happened to it or if it's been pulled down and replaced somewhere with another link or something. People versus Horton is one that actually is stated many times that you see on these traffic stops, for example, on the Van Balen channel. So I do want to address it. So People versus Horton. This case involves a criminal stop, not a traffic stop, and criminal law does not apply to traffic stops. But amateur legal theorists confuse criminal law with traffic law and therefore mistakenly interpret this case to mean that an officer may not lawfully make a routine traffic stop unless the officer has witnessed the driver engaging in a crime. In this case, there was no traffic violation like speeding or having an expired tag to justify a routine traffic stop. Instead, the officer here made a criminal stop of a car solely because it contained young people. The officer saw marijuana in the car, reflecting the crime of possession. Arrested the occupants. In holding the criminal stop unconstitutional, the court recognized the right of the citizen to drive on a public street with freedom from police interference, referring to illegal criminal stops, unless he is engaged in suspicious conduct associated with criminality, not the alleged right to drive or operate a motor vehicle without a driver's license. At the sixth paragraph, at about 75% of the way through the text, thus contrary to the claims of the amateur legal theorist, this case does not require officers to witness a crime to make a lawful traffic stop. This case does not authorize driving or operating a motor vehicle without a driver's license, and this case does not prevent the states from requiring driver's licenses. Not that it makes any difference, but the case does not has no application outside of the state of California. Now we're going to take a look at People versus Glover. So this case will be located directly in the link of the link will be in the description of this video for you to follow along. I apologize that I can't find Horton. I don't know what has happened. This case, we're speaking of People versus Glover now, involves a criminal stop, not a traffic stop, and criminal law does not apply to traffic stops, but amateur legal theorists confuse criminal law with traffic law and therefore mistakenly interpret this case to mean that an officer may not lawfully make a routine traffic stop unless the officer has witnessed the driver engaging in a crime. In this case, there was no traffic violation like running a stop sign or driving down the wrong side of the road or anything to justify a routine traffic stop. Instead, the police officer here set up a roadblock solely to catch an armed robber, a criminal, fleeing from the scene of the crime. The police made a criminal stop of every single car. The police caught the robber, but the court held that the criminal stop was unconstitutional and quoted the Horton case, the one directly before this that I was talking about, which recognized that the right of a citizen to drive on a public street with freedom from police interference, referring to illegal criminal stops, unless he has engaged in suspicious conduct associated with criminality, not the alleged right to drive/operate a motor vehicle without a driver's license. So, if you go down to the 15th paragraph at about 85% through the text, thus contrary to the claims of amateur legal theorists, this case does not require officers to witness a crime to make a lawful traffic stop. This case does not authorize driving or operating a motor vehicle without a driver's license, and this case does not prevent the states from requiring driver's licenses. Not that it makes any difference, but this case has no application outside of California. All right, so next we're going to be looking at Mills versus District of Columbia. I apologize, I quoted the wrong case. We're going to actually be looking at Spokane versus Port, another one you guys hear regularly from these individuals on these traffic stops. So, again, the link will be in the description of the video if you want to follow along. Right and privilege have assumed a variety of meanings depending upon the context in which they are used. Whether it is a term, a right, or privilege, one's ability to travel, use the drive/operate on public highways is always subject to reasonable regulation by the state in the exercise of its police powers. Traveling, using, and driving/operating on public roadways is always subject to such reasonable regulation under the state's police power. States may require driver's licenses, quoting the Supreme Court decision in Hendrick versus Maryland, the very first case at the very beginning of part 1 of this Snoop4Truth right to travel grouping, which is still the law today. At the 4th paragraph, at about 40% of the way through the text, thus whether driving/operating a motor vehicle is characterized as a quote right or a quote privilege, the states may require drivers and operations of motor vehicles to have driver's licenses. Drivers/operators of motor vehicles do not have an unregulatable right to drive or operate without a driver's license, and there is no decision in the history of the United States that says so. None. Okay, so our final case that we're going to be looking at today is Shuttlesworth versus Birmingham. You can follow along with the link in the description. Finally, these amateur legal theorists that cite Shuttlesworth versus Birmingham in support of their false claims that a person may ignore state driver's license laws and drive or operate a motor vehicle without a driver's license with impunity. How do these legal theorists reach this absurd result? This is because in all of the cases that I just showed you today, they inartfully characterize driving/operating a motor vehicle as a quote-unquote right, although they also hold that this quote-unquote right may be regulated, granted, denied, or revoked, or what most courts characterize as a privilege, regardless, because they mistakenly conclude that operating/driving a motor vehicle is a unregulatable right. Amateur legal theorists mistakenly conclude that all driver's license laws in the country must be unconstitutional. Then amateur legal theorists combine that mistaken conclusion with the following language in Shuttlesworth versus Birmingham, which reads in part, "A person faced with such an unconstitutional licensing law may ignore it and engage with impunity in the exercise of the right." But see, the whole truth about this language is below. In Shuttlesworth, the city of Birmingham had in force an ordinance which required all leaders/organizers of all political marches to apply for and obtain a license from a city commission prior to such a political march. The city commissioners which reviewed all such applications were all white and had complete unlimited discretion to grant or deny such permits. A black minister seeking to hold such a political march in Birmingham in protest of racial injustice twice attempted to apply for such a permit and was twice told by the city before even filling out the application that a permit would not be granted. As a result, the minister did not fill out the application or receive a permit. On Good Friday in 1963, the minister led the subject march for 4 blocks on the sidewalks of Birmingham and was arrested, convicted, sentenced to jail and hard labor for violating the subject license law. The Supreme Court of the United States reversed the minister's conviction and held that the subject ordinance was unconstitutional because of the complete unlimited discretion it afforded city officials to restrain free speech, not driving or operating a motor vehicle. The court wrote as follows: "It is settled that an ordinance which, like this one, makes the peaceful enjoyment of freedoms which the Constitution guarantees, referring to the freedom of speech, contingent upon the uncontrolled will, the uncontrolled discretion of an official as requiring a permit or license, which may be granted or withheld in the discretion of such official, is an unconstitutional censorship or prior restraint upon the enjoyment of those constitutional freedoms, referring to the freedom of speech. A person faced with such an unconstitutional free speech licensing law, which affords a government official the complete unlimited discretion to grant or deny the license, may ignore it and engage with impunity in the exercise of the right of free expression." Let's really think about this for just a second, you guys. So we're talking about in Shuttlesworth versus City of Birmingham. We're talking about something that required a license in order for people to walk down the road. Has nothing to do with a driver's license, nothing to do with operating a motor vehicle. But yet these people are out there spreading this as gospel, because it was ruled later to be unconstitutional due to freedom of speech. Had nothing to do with right to travel whatsoever. Contrary to the claims of Eddie Craig and other amateur legal theorists, this case does not authorize people to ignore the driver's license laws and engage in impunity in the exercise of the right to operate or drive a motor vehicle without a driver's license. There is no case in the history of the United States which holds that a person has a right to drive/operate a motor vehicle without a driver's license, and those are the only words that legally matter. Substitute words and substitute rulings and substitute cases will not work. They are not legal. They are not complete. They are cherry-picked. They are hoaxes. They are false. They are lies. Let me say that one more time. There is no case. All you Sovsits and Moors, are you hearing me? There is no case in the history of the United States which holds that a person has a right to drive or operate a motor vehicle without a driver's license. And those are the only words that legally matter. Your cherry-picked bullshit will not stand up in court and never has. All right, so I want to thank Snoop4Truth for all of his wonderful research. Thank you so much for providing us with all of this wonderful case law. I will make sure that all of the links that I was able to get to are in the description of this video for those of you that would like to follow along or read over the cases, which are, by the way, very interesting for those of you that like to read case law, that are in the description of this video. And I hope everybody got a good idea in this part 2 of the confusion that a lot of these amateur legal theorists have, specifically Mr. Eddie Craig, and really anybody else who's pushing this right to travel argument, where they're claiming that you're allowed to drive without a driver's license. And specifically, let's just talk about this one more time. We Are Change. Okay, wearechange.org talks about the Supreme Court and how they ruled. Nothing about this is true. It's not true. They never ruled that no license is necessary for normal use of an automobile on common ways. That's not what happened. But it's what they continue to spread. It's how they get people ticked off. It's how they raise the hate and anger level so that people will buy in to their BS. All right, everybody. I hope you have a great day. For comments, please make sure that you let me know what you thought of this Snoop4Truth episode. Thank you once again to Snoop for all of the research. And for those of you that have questions that don't want to put them in the comments section, you are more than welcome to email me at virgotriad@protonmail.com. And for those of you that are looking forward to next Friday's Patreon mini doc on the history of the Moors, in order to see that, all you have to do is donate $1 on my Patreon account. Go to www.patreon.com/VirgoTriad1. The link will be in the description of the video. Thanks so much, everybody. Have a great day.